This episode examines a real, unresolved disappearance. It does not accuse individuals or speculate beyond documented facts. All information presented is based on publicly available records. This episode examines a real criminal case and its legal outcome. It does not claim to resolve what ultimately happened. August 19, 2011. On the steps of a courthouse in Jonesboro, Arkansas, a story that had captivated and divided people for nearly 2 decades seemed to be reaching its conclusion. For the supporters who had gathered, who had campaigned for years, this was a moment of vindication. For the global media, it was the final, dramatic scene. When the gates of the Craighead County Detention Center finally opened, many people believed the story was over. The long, dark chapter was closing. 3 men walked free. Damian Eccles, who had spent half his life on death row. Jason Baldwin and Jesse Miskelly Jr., who had entered prison as teenagers and now emerged as middle-aged men. 18 years, 7 months, and 23 days of incarceration had ended. On paper, a legal resolution had been reached. The men had entered what is known as an Alford plea, a complex and controversial legal maneuver. It allowed them to plead guilty while simultaneously maintaining their innocence, a bargain struck to secure their immediate freedom. The state, in turn, could close the case without admitting to a wrongful conviction. It was a correction, of a sort, a compromise designed to end a stalemate. But as the men were whisked away from the cameras and the crowds, a profound sense of incompleteness hung in the air. Their freedom was not an exoneration. The plea deal had released them from their sentences, but it did not clear their names. It did not erase the guilty verdicts from their records. And because of that, something critical did not arrive with them. An answer. To find the beginning of that missing answer, you have to go back. Back to May 5, 1993, in the small working-class city of West Memphis, Arkansas. On that spring evening, 3 8-year-old boys, Stevie Branch, Michael Moore, and Christopher Byers, went out to ride their bikes and never came home. The next afternoon, their bodies were discovered in a muddy drainage ditch in a patch of woods known as Robin Hood Hills. The crime was brutal, and it horrified the deeply religious, tight-knit community. West Memphis was a town grappling with economic hardship, a place where everyone knew their neighbors. The discovery of such a violent act in their midst felt like an invasion, a violation of the town's very soul. A wave of fear and grief washed over the city, and in the face of such profound horror, that fear demanded an explanation. It demanded a story that could make sense of the senseless. The pressure on the West Memphis Police Department was immense and immediate. The media descended and the public clamored for arrests. Investigators, working with the limited forensic tools of the early 1990s, began to build a narrative. This narrative wasn't born from a single piece of irrefutable evidence. Instead, it was shaped by a confluence of factors: the urgency to calm a terrified public, the cultural anxieties of the time, and the prevailing beliefs about what evil looked like. The story that emerged centered on teenagers who listened to heavy metal music, read horror novels, and wore black. It was a story of a satanic cult, a narrative that tapped into a widespread moral panic sweeping the nation at the time. The story felt coherent. It provided a monster that was identifiable, if misunderstood. It offered a motive, ritual sacrifice, that, while horrifying, fit a pre-existing template of evil. In moments of collective panic, the human mind seeks patterns and explanations. We crave a narrative that organizes chaos into a cause and effect structure. And in that desperate search for order, the coherence of a story can often matter more than its factual accuracy. The convictions of Damian Eccles, Jason Baldwin, and Jesse Miskelly Jr. were not built on a single, catastrophic failure of the justice system. There was no one moment, no single piece of fabricated evidence that sealed their fate. Instead, they were built on accumulation, a slow, creeping accretion of seemingly small pieces that, when woven together, formed a damning tapestry. It began with rumors and town gossip, which led investigators to focus on Damien Eccles as an outsider. It continued with the interrogation of Jesse Miskelly Jr., a teenager with a low IQ, who, after nearly 12 hours of questioning without a parent or lawyer present, gave a confession that was riddled with inconsistencies and factual errors. That confession, however flawed, became the cornerstone. From there, every subsequent piece of information was viewed through the lens it provided. Statements from jailhouse informants, interpretations of the defendant's interests and appearance, and assumptions about their character all reinforced one another, creating a feedback loop of confirmation bias. Each element on its own might have seemed weak or questionable, but together they created a powerful narrative momentum. To the police, the prosecutors, the jury, and much of the public, the case made sense. It was a complete story with a beginning, a middle, and an end. It had heroes, the investigators who caught the killers. It had villains, the satanic teenagers. And it had a resolution, a guilty verdict that promised to restore safety and order. And once a story makes that much sense, once it becomes the accepted truth, it develops an inertia that is incredibly difficult to stop. It resists disruption. It pushes back against contradictory evidence, reinterpreting it or dismissing it outright to protect the integrity of the original narrative. The system had its story, and for 18 years, it held on. For nearly a decade, the case was closed, the verdict filed away, the narrative set in stone. But the passage of time does not always cement a story. Sometimes it erodes the foundation. Years later, questions emerged, not all at once. There was no single dramatic revelation that shattered the official account. It wasn't a bombshell dropped on the evening news. Not dramatically. It began as a whisper, a quiet current of inquiry running beneath the surface of the accepted facts. It started in the periphery, a law school innocence project taking on the case as an academic exercise, an investigative journalist following a cold lead on a slow news day. But persistently, each inquiry, no matter how small, uncovered another loose thread. Each question asked by a new set of eyes revealed a detail that didn't quite fit. What began as a trickle of doubt soon grew into a steady, unyielding stream of scrutiny. The initial focus was procedural. Concerns about evidence handling. The chain of custody logs, meant to be an unbroken record of every person who handled a piece of evidence, showed gaps. Time frames where items were unaccounted for. Signatures that were illegible or missing. Then there were questions about the statements. Key witness testimonies, when re-examined years later, revealed subtle but significant inconsistencies with one another, and even with their own earlier accounts given to police. And most critically, there was the question of what was weighed and what was ignored. An alibi witness who was never called to the stand. A piece of physical evidence from the scene that didn't match the defendant, which was dismissed at the time as an irrelevant anomaly. The original investigation had constructed a linear, compelling story, but only by trimming away the details that didn't fit. Doubt does not arrive loudly. It doesn't announce itself with a gavel or a headline. It accumulates. A single inconsistency is a curiosity. 2 become a coincidence, but a dozen, 100, they form a pattern, a weight. Each small discrepancy, each procedural misstep, each overlooked fact added another layer to the growing burden of uncertainty. The case file, once a tidy summary of guilt, was becoming a heavy, sprawling archive of unanswered questions. Then, science intervened. Advances in forensic testing introduced new uncertainty. Techniques that were considered cutting edge at the time of the trial were now seen as rudimentary, even unreliable. New methods for DNA analysis, far more sensitive than what was available before, were brought to bear on the original evidence, which had been carefully preserved in climate-controlled storage. The results provided not definitive answers, but destabilization. The new tests couldn't conclusively prove innocence, but they failed to replicate the original findings that had so strongly pointed toward guilt. Unidentified DNA profiles were discovered on key pieces of evidence. The scientific certainty that had underpinned the prosecution's case was now fractured. The new data didn't create a new story. It simply proved the old one was flawed. With its scientific pillars weakened and its procedural integrity questioned, the original story no longer held as tightly. The narrative that had once seemed so robust and convincing was now brittle, fragile, and beginning to crumble under the combined weight of legal review and scientific progress. And when a story loosens, the system faces a choice. It is a fundamental crossroads for any institution of justice. Does it double down, defending the original verdict at all costs to preserve the appearance of infallibility? Or does it acknowledge the uncertainty and seek a new path, rebuild it, or step away? To rebuild would mean a new trial, a monumental undertaking. To step away would mean admitting the system, for all its safeguards, had produced a result that was no longer tenable. By 2011, after years of legal motions, appellate briefs, and media attention, the system confronted its limits. The accumulation of doubt had become too significant to ignore. The state was faced with a difficult reality. A full retrial would require revisiting everything: evidence, testimony, credibility. But more than a decade had passed. Memories had faded. Some witnesses were no longer available. Others had passed away. Evidence that was once fresh was now old. The new forensic results complicated, rather than clarified, the picture. Prosecuting the case again would be extraordinarily difficult, and the outcome would be far from certain. The cost, both financial and in terms of public trust, would be immense. Instead, another path was chosen, a path that exists in the gray area of the American legal system, designed for situations precisely like this one, where the chasm between guilt and innocence has become a murky, impassable fog. An Alford plea allows a defendant to maintain innocence while acknowledging the court believes enough evidence exists for conviction. It is a complex and often misunderstood legal maneuver, named for a 1970 Supreme Court case. The defendant does not admit guilt. Instead, they state that while they are innocent, they recognize that the prosecution has enough evidence that a jury could reasonably find them guilty. It is a pragmatic concession. It is a legal compromise. For the state, it avoids the risk and expense of a new trial and allows the original conviction to stand, albeit in a modified form. It prevents a formal exoneration that could imply wrongdoing or error on the part of the police or prosecutors. For the defendant, it offers an immediate path to freedom, ending the uncertainty and protracted battle of the appeals process, a correction without confrontation. The plea allows the system to correct a potential injustice without having to formally admit one. It sidesteps the difficult public process of dissecting what went wrong. It is a resolution that satisfies the procedural needs of the court, but leaves the central question of what truly happened unanswered. The result is freedom, without a declaration of truth. The prison doors open, but the official record is not cleared. The defendant walks free, but the shadow of the original conviction remains. It is an imperfect solution for an imperfect system, a way to end a story that can no longer be told with confidence without ever writing a new one. The end, when it came, was not with a bang, but with the quiet turning of a key in a lock. The men were released. After years spent inside a system that had declared them guilty, the same system, with far less ceremony, declared them free. There were no grand pronouncements from the steps of the courthouse, no triumphant press conferences, just the hushed finality of paperwork and the surreal experience of walking out into a world that had moved on without them. This wasn't a victory parade. It was an administrative procedure. The legal machinery, having ground them down for so long, simply reversed its gears and pushed them back out, leaving them blinking in the unfamiliar sunlight. The state, for its part, avoided a retrial. The decision was framed as a matter of judicial economy and pragmatism. Why expend taxpayer money and court resources to relitigate a case where the foundational evidence had crumbled? Witnesses' memories had faded. Some were no longer available, and the physical evidence itself was now tainted by the revelation of its mishandling. A new trial would be a monumental undertaking, with a deeply uncertain outcome. For the prosecution, the original narrative had been shattered. Attempting to piece it back together for a new jury would be like trying to rebuild a house from rubble. It was easier, cleaner, to simply walk away. And so, with the stroke of a pen on a document known as a nolle prosequi, a formal notice of abandonment by a plaintiff or prosecutor, the case, legally speaking, was finished. The charges were dropped, the convictions vacated. In the cold, hard ledger of the law, the accounts were settled. The file would be moved from an active cabinet to a deep storage archive, its journey through the justice system complete. For the courts, for the district attorney's office, this was closure. It was the resolution of a complex and now unwinnable legal problem. The system had identified an error, a conviction it could no longer stand behind, and it had corrected it. Case closed. But the central question, the one that had haunted this case from the very beginning, remained untouched, unanswered, and perhaps unanswerable. If these men didn't do it, who did? The system, in its haste to close the file, offered no answer. It provided an exit for the wrongly convicted, but created no entrance for a new investigation. The crime itself, the violent act that started this entire chain of events, was now an orphan, a tragedy without a perpetrator, a story without an ending. The original harm was left unaddressed, floating in a void of legal procedure. The focus was on undoing the mistake, not on finding the truth that the mistake had obscured. Here is the stark, uncomfortable realization this case leaves behind, a lesson written in the margins of its voluminous files. It is a lesson about the very nature of our justice system and the fundamental limits of what it is designed to do. We look to the courts for truth, for a definitive narrative that separates fact from fiction, guilt from innocence. We expect a story with a clear beginning, a logical middle, and a just end. But this case demonstrates that the system's primary function is not storytelling. It is process management. It is about applying rules, meeting standards of proof, and achieving what is known as legal finality. The system corrected the error it could prove. The new evidence, the DNA, the recanted testimony, whatever it was, created a fatal flaw in the architecture of the original conviction. It met the legal standard for reasonable doubt, and then some. The conviction was no longer sustainable under the rules, and so the rules were followed, the conviction was undone. This is the system working, but only within the narrowest definition of its function. It is a mechanic fixing a broken part. The car now runs, but the mechanic has no obligation to tell you how the part broke, who broke it, or where the car was really supposed to go. It did not, and perhaps could not, replace the story it dismantled. The original narrative, however flawed, was a complete one. It had villains, a motive, a sequence of events. It offered an explanation that, for a time, satisfied the community's need for order and understanding. When that story was proven false, a vacuum was created. The system offered nothing to fill it. It did not provide a new, true story. It simply stated that the old one was incorrect. It's the difference between a historian debunking a myth and then writing the true history, versus one who simply puts a red X over the myth and walks away, leaving a blank page. Correction is not the same as explanation. This is the core dilemma. A correction is a reversal, an undoing. An explanation is an understanding, a clarification. The court's action was a correction. It acknowledged that A is not B, but it never ventured to define what A actually is. It never explained how the investigation went so wrong, how evidence was misinterpreted, or how a jury was convinced of a fiction. Was it incompetence, a lack of resources, or something more deliberate? Without an explanation, the correction feels hollow, incomplete. It fixes the outcome, but it doesn't heal the wound. Justice, in our cultural imagination, often promises meaning. It promises that in the end, things will make sense. It promises that the guilty will be punished, the innocent will be vindicated, and the truth will be known. We see it in films, we read it in books, the dramatic courtroom revelation, the confession, the moment where all the pieces click into place. We have been conditioned to expect a satisfying conclusion, a moral to the story. We believe the scales of justice don't just balance, they clarify. This case, and so many like it, delivered something else entirely. It delivered a legal product, not a philosophical truth. It provided an answer that satisfies the code of criminal procedure, but leaves the human heart aching for more. It is the cold comfort of bureaucracy. The system did not fail in this final act. On the contrary, it performed its corrective function as designed. The failure is our expectation that the system's function is to provide the kind of deep narrative resolution that we, as human beings, crave. What we are left with is a series of unsettling paradoxes. Relief without resolution. The men are free, but the community is no closer to resolving the original crime. Freedom without truth. They are unchained from their cells, but not from the unanswered questions that will follow them for the rest of their lives. And finally, an ending that refuses to explain the beginning. The final chapter of the legal saga has been written, but it renders the first chapter utterly incomprehensible. It's a book with its last page intact, but its first page torn out. We assume that fixing a mistake restores the truth. We believe that when a wrongful conviction is overturned, the truth of what really happened will naturally surface, as if it were just waiting beneath the surface of the lie. We think of it like a mathematical equation. If you remove the wrong answer, the right one must appear. This case teaches something harder, something more profound and disturbing. It teaches that the opposite of a lie is not always the truth. Sometimes the opposite of a lie is simply a void. Sometimes correction only reveals the depth of our ignorance. It doesn't replace a false certainty with a true one. It replaces a false certainty with a vast and terrifying uncertainty. It shows us, in the starkest possible terms, how much we never knew. This is Armchair Files, and this was File 16. If this episode challenged how you think about justice and resolution, share it with someone who believes fixing the system always reveals the truth. The conversations that arise from these empty corrections are essential because they force us to confront the limits of the institutions we rely on for answers.